I'm trying to understand how your rule is workable in any real way, even with that example. So suppose you have an 80-year-old prisoner who has cancer, and I take it that your rule is that that's the kind of classic personal circumstance that can be considered in the context of compassionate release. But that could also be considered in the context of a habeas motion with respect to something like the tolling issue that you raised. So I guess I don't understand why you're saying, or how you could be saying, that anything that comes up in the context of habeas can't be ever considered in this context. And maybe I have your rule.
We're not saying anything that could ever be relevant.
Okay, so
habeas.
What are you saying?
So I'm not saying, like, for example, equitable tolling, like I was in a coma, that could, I suppose that might affect someone's claim of illness under Section 3582 motion. Our argument is that something that would be grounds for attacking the validity of the original criminal judgment, that is, the kind of thing that would be raised as a Section 2255 claim. This would be the claim, not just some attendant circumstance to the claim that might be used for something like equitable tolling, can't be advanced as
even if you're not trying to advance it to attack your sentence in this context, even if you accept that your sentence is valid.
That's right, Your Honor, because by hypothesis, anything else the prisoner is alleging, for this question ever to make a difference, nothing else the prisoner alleges is itself going to be extraordinary and compelling enough. So what gets them over the line in these kinds of cases, in order for the question presented in this case to matter, the thing that gets them over the line has to be the Section 2255 claim. I don't think what Congress wanted was for someone to come in and have reasons that aren't enough to get him over the line. So the canonical example being rehabilitation, the court says no, and the prisoner says, well, here's my ace in the hole. It's a Section 2255 claim. Now, it would never get anywhere because it's substantively deficient and it would be wildly out of time, and I've already filed a Section 2255 motion, but hey, here's what I got, and if you add this to my rehabilitation, which is insufficient,